So you filed your first patent application. Should you conduct an examiner interview with your patent examiner? Let's talk about that. So unfortunately, many people view the interaction with the USPTO patent examiner as some kind of a battle or some type of a litigation. And it shouldn't be viewed that way. It's not a litigation and it's not a battle. It's not a fight. Really, what the interaction with the examiner is a kind of negotiation. The examiner has a duty to keep things in the public domain. So the reason that they examine your claims and make rejections of your claims is that they're trying to prevent things that should be in the public domain from getting taken out by assigning patent rights too broadly. The idea is that a certain amount of technology should belong in the public domain so that everybody can use it. If there's inventive subject matter that's different from what's in the public domain, then under our Constitution and our patent laws, inventors have the right to claim for a limited period of time rights to that invention to prevent others from making, using, and selling it. So the patent examiner's job is very important because they're not only trying to determine what patent rights you should be entitled to, but they're protecting the public from granting too many patent rights and taking things out of the public domain that should remain in the public domain. So there's a balance, and they have to be very careful about what claims they allow versus what claims they don't allow. Making that determination is not easy. The examiner has to search for prior art, look at that prior art, and make a determination of whether that prior art is teaching exactly your subject matter, which would warrant a 102 novelty rejection, or whether there is some combination of references that would teach or suggest your subject matter to warrant a 103 obviousness rejection, and this is not an easy determination to make. By conducting an examiner interview, you can help the examiner and also yourself by getting a clearer understanding of how the examiner views your claims with respect to the prior art and what the examiner believes may be allowable in your claimable subject matter over what's disclosed in the prior art. So an examiner interview can be informative for both the examiner and you as the applicant. And so for that very reason, I recommend conducting an examiner interview if you have the opportunity to do so. One opportunity to do that would be when you receive a first office action. When you receive a first office action, more likely than not, you're going to have a rejection of your claims. It may be under 102 novelty, maybe under 103 obviousness. It may be both types of rejections. There may be other rejections as well, such as 112, or even a rejection under patentable subject matter under Section 101 of the patent law. But in any of those circumstances, having a discussion with the examiner can be helpful. One of the reasons is reading the rejection on paper doesn't always get you inside the mind of the examiner and doesn't always give you a clear idea of what the examiner's thinking process really is. By talking to the examiner, you can get clarification and have a much better understanding of how the examiner is viewing the prior art, why the examiner is applying it in the way that they are, and what the implications are for your claims. In many cases, you may be able to suggest amendments of your claims to the examiner for the examiner's consideration in terms of how you see the prior art, and that may help to get you to an allowance of your patentable subject matter. Another advantage to conducting the examiner interview is that if you disagree with the examiner in terms of the way that he's interpreting the prior art, you can explain your invention, what it's doing, and what you believe the prior art is teaching, and then explain those differences to the examiner in a verbal communication, which is much easier to do than putting all of those arguments and talking points on paper. Also, it allows you to make adjustments if the examiner is misunderstanding. You're having a real-time communication, and so you can make clarifications at that time. Now, the examiner may still require you to submit a written amendment or written remarks that still put on paper the arguments that you're making, but because you talk to the examiner, you're going to have a much clearer understanding of what you need to argue in order to show the examiner that your claims are patentable over the prior art. And so from that standpoint, it's a very good idea to have the examiner interview. So in general, having an examiner interview is a sensible thing to do. I would recommend doing it on a first office action. If you're getting a 102 and a 103 in the first office action, it's probably a good idea to have a discussion with the examiner to understand the examiner's position, to make your position clear. One suggestion I would make is that before you conduct an examiner interview, when you get a first office action, you're really going to want to dig through the references that the examiner is citing, understand them as well as you can with respect to what they're teaching, and know what your arguments are for how your claims distinguish from what's taught in those references. Once you do that, you're ready for the examiner interview. You can talk to the examiner and elaborate on either how you believe the examiner may have misinterpreted that reference or how your claims are differentiating from the reference. So in general, conducting examiner interviews is a very good practice. It's part of the back and forth that needs to occur between the examiner, but it aids in the understanding of the examiner's argument. It helps you to better understand your own arguments against the prior art, and it gives you an opportunity to make much better arguments on paper when the time comes to file a paper response to the examiner's rejections. So overall, examiner interviews, a good thing. Conduct them, do them, enjoy them, and they will benefit you in your journey toward obtaining patents on your inventions.